Awutu Ellies Kaate and others versus the Republic. In the case of Awutu Ellies Kaate and others versus the Republic, the court dealt with a serious matter involving the misappropriation of public funds by officials within the Department of Urban Roads in Sekondi. The first appellant, who was the chief accountant, along with another officer, was found guilty of various crimes including forging official documents, falsifying accounts, and stealing government money that was meant to be paid to the tax authorities. An audit conducted in early 2006 revealed that approximately 126,875 Ghana cedis in withholding tax payments had been diverted by altering payment vouchers and changing the names on checks to secretly move the money into accounts they controlled. Although the first appellant claimed he made a confession under pressure, the court found his statement to be voluntary and supported by strong evidence, including the audit findings and testimony. On appeal, the defense argued that there was no direct proof of the theft and that the confession was unreliable, but the Court of Appeal disagreed and upheld the convictions. The court confirmed that the changes to the checks were intentional and dishonest, and that the actions clearly violated legal rules about forgery, falsifying records, and stealing. As a result, the first appellant was sentenced to 5 years in prison and fined 40,000 Ghana cedis, while the second appellant received a similar sentence and a 20,000 Ghana cedis fine. In its final judgment, the court emphasized that public officials who misuse taxpayer money will be held accountable, and that maintaining trust and integrity in public service is essential. It must, however, be noted that, on appeal, counsel for the first accused urged the Court of Appeal to uphold and apply the decision by the Supreme Court of Ghana in the case of Frimpong, alias Iboman, versus the Republic, where the court held that a police officer or a member of the armed forces was prohibited from acting as independent witness to a confession statement. To this extent, the Apex Court declared the confession statement given by the accused in that case as inadmissible on the grounds that it was witnessed by a police officer contrary to the Evidence Decree, NRCD 323. This decision was found to have been made contrary to law by the Court of Appeal, and to that extent, they were not bound to follow, as generally required under Article 129(3) of the Constitution, 1992. A key observation made by the Court of Appeal was that, at the time of the Supreme Court's decision in the Iboman's case, the NRCD 323 had been amended by Evidence and Criminal Procedure Amendment Decree 1979, SMCD 237, which made a police officer or a member of the armed forces eligible to witness a confession statement approved by the accused. It thus seems, with the utmost respect to the Apex Court, that it failed to take notice of this amendment, which was the true position of the law at the time, but rather upheld a repealed law in favor of the accused. The Court of Appeal, in response to counsel's argument, ruled that an existing law is superior to judgments, and to the extent that the said Supreme Court decision was made contrary to an existing law, they were not bound to follow it. Clearly, one can observe that the Supreme Court of Ghana gave its blessings to this position taken by the Court of Appeal. This became evident in its decision, the case of Eco Russell v. the Republic, which followed the decision of the Court of Appeal in the case of Ellies Kaate. In the Eco Russell's case, the Supreme Court affirmed the position taken by the Court of Appeal that a police officer and a member of the armed forces may act as independent witness.